Okay, this is People of the State of Michigan versus Delvante Coleman, docket number 20-903FH. And this is the defendant's motion to modify bond. And Mr. Coleman is present with Mr. Hess as his attorney and Ms. Allen for the people. You can go ahead with your motion, Mr. Hess.
Thank you. Thank you, Your Honor. With respect, Edward Hess appearing on behalf of Mr. Coleman. I'm appearing remotely via video. Mr. Coleman appearing from the county jail. This matter was recently set for a pretrial conference that was conducted off the record between myself and Ms. Allen. Discussions are ongoing as to an appropriate resolution of this case. Just for the record, I believe the hang up at this point is whether Mr. Coleman would have to do additional jail time prior to his sentencing on a charge of aggravated stalking. As far as the bond motion goes, Your Honor, right now the bond is $100,000 cash surety. Mr. Coleman has been out of work for a while. There's absolutely no way he can afford to post that bond. In practical terms, a $100,000 bond either means putting somebody's house up or paying more than $10,000 to a bail bondsman. So even though technically he is being held with an unposted bond, it's almost like being held without bond at this point. The presumption of the court rules is that we start from a place of releasing someone on personal recognizance, and then it's personal recognizance with conditions. And then if even those conditions aren't enough, then the court is permitted to set either a cash surety or a 10% bond. The court has a lot of options when it comes to setting conditions. The answer filed by the prosecutor relied heavily on the preliminary examination transcript. There are some very serious allegations made by Ms. Tiara Taylor, who identified herself as Mr. Coleman's former girlfriend in the preliminary examination. The charges stem from alleged threats to Ms. Taylor. It's not a case where Mr. Coleman's accused of violating any court order. Rather, the allegation is that his behavior was threatening enough and repeated enough to count as criminal behavior. So there are serious allegations, and I do understand the district court's concern in setting this bond. But you know, we're not really so concerned about what the district court did. I believe that this court has enough on the record to make an independent decision as far as the bond goes. And Your Honor, if we're not able to resolve this case soon, Mr. Coleman will still be in custody awaiting trial date. Not really sure when that's going to happen. So just looking at some of the factors in the court rules, at this point, we do have housing verified for Mr. Coleman. That would be with his girlfriend, Mercedes Sims. That was verified by the pretrial services investigator in her bond report. Mr. Coleman's not currently employed, but he has told me he never has trouble finding work, either some sort of manual labor, or working as a cook, food service. And I believe, Your Honor, that there are appropriate orders that the court could enter to ensure, A, that Mr. Coleman returns to court, and B, ensure the safety of the alleged victim, in this case, Ms. Taylor. Namely, Your Honor, the use of GPS tether technology could set up exclusion zones and victim notification just to ensure that Mr. Coleman is staying far away from both the Stonegate Trailer Park, where the alleged incident in the criminal complaint occurred, and also from Ms. Taylor's house on Malcolm X Avenue in Lansing. Those could be set up as probably 1 mile or half-mile exclusion zones. And then because of his indigent status, Mr. Coleman could apply for an indigent tether grant through JSG, Your Honor. So all of this is possible. I understand the allegations are shocking and unpleasant. We should also balance that with Mr. Coleman being presumed innocent, having secure housing with Ms. Sims, and the fact that this defendant is simply not going to be able to afford to post the very high bond. So I would ask at the absolute minimum that the court at least reduce Mr. Coleman's bond to the point where he might be able to scrape some money together to post it. But what I would really ask for would be that Mr. Coleman be released on personal recognizance with appropriate and strict bond conditions, including GPS tether, to ensure that pretrial services always knows where he is and to ensure that he's staying far away from Ms. Taylor. I will note for the record that the bond report did recommend that Mr. Coleman not be released on personal recognizance, but that's based on a mathematical formula, and it is not a substitute for the independent judgment of this court. So I would ask the court to consider all of the items on the record, including the both motions filed and the bond report, and consider reducing Mr. Coleman's bond. Thank you, Your Honor.
Thank you. Ms. Allen?
Thank you, Your Honor. We filed a written response, and as Mr. Hess has indicated, we did quote the preliminary examination transcript, and doing so because that was testimony taken under oath about the facts, and I think it gives the court a bigger picture as to what occurred in this case. And pointing specifically to two things Mr. Hess mentioned. First, about defendant saying he will live with Ms. Sims. Actually, in the bond report, he said he was living with her when this whole thing happened. So one aspect of the court rule, MCR 6.106F1D, is the availability of responsible members of the community who would vouch for or monitor him. And he would be going to allegedly live with the same person he was living with while he committed all of these crimes to begin with. And the second part being is, Mr. Hess noted there were two different places where these crimes took place. And that's the most disturbing aspect, is that once the victim moved and tried to go to a place where she was hidden from this defendant, he then went to that second location. And even while the police were present, attempting to stop him, he still tried to physically break into the home. And so the nature of this conduct is repeated and escalated destruction, threats, moving to two different locations where the victim has tried to separate herself from him and tried to physically make herself safe. And he has found her and followed her, even in the presence of police, continued that destruction and the threats. And so those two aspects of it in response, I would add, in addition to what I wrote in my motion, are the two biggest concerns I have. And also that the bond report would not recommend him being released on a personal recognizance bond. As Mr. Hess has said, we are talking about a potential plea agreement. We're working towards that, but we also have trial dates now beginning, in April, and I'm feeling positive and optimistic we would get to those. And with him being in custody, if he remains in custody, he'd be a priority. So we'd ask the court to deny the motion. Thank you.
All right, thank you. Well, the defendant doesn't contest that the allegations here are shocking. And so I would just say that I did have the benefit in the people's response of having the facts of the case as testified to at the preliminary exam given to me. And they are indeed shocking that this event took place allegedly over the course of 4 days. It involved repeated contacts by the defendant, repeated incidents where he went into Ms. Taylor's home and essentially destroyed almost everything in the home, committing way over the top, horrendous destruction in her home, and did it on multiple occasions. And as the prosecutor noted, and as I noted as well, did it even was assaultive and threatening even in the presence of police. So, I mean, the reason that's important to the court is that it shows that he can't conform his behavior even when a police officer is standing there, which makes the factor of the seriousness of the offense charged very high. And also what one would question almost his mental condition. This does not reflect a one-time impulsive act, but a number of acts over the course of days where the activity that's alleged is just outrageous. I'm not very much comforted by the defendant's proposed release address because, as the prosecutor noted, that's where he was living according to the bond report when these alleged offenses occurred. But also it's with Ms. Sims. And as I understand the testimony from the preliminary exam is that Ms. Taylor continued to get calls from the defendant once he was arrested from the jail. And it says she also received calls from the defendant's phone from Ms. Sims. And that's after he's been arrested for this. So the fact that he would be living with Ms. Sims is of no comfort whatsoever. I would consider the... and he's got at least 3 prior although I think they were misdemeanors, but 3 prior assaultive offense convictions or convictions in combination of conviction and juvenile adjudication. But juvenile offenses are relevant to the court's determination. So there is the prior record, his apparent out of control, beyond impulsive mental condition, the seriousness of the offense, and the lack of ties to the community, although he says he's lived in Ingham County for 5 years, but I would call his residence somewhat unstable. And certainly don't have responsible members of the community who would vouch for him and monitor him. So I see no factors that weigh in favor of the defendant being released on bond or having his bond lowered in this case, and I am denying the defendant's motion to modify bond. And that will conclude our hearing.
Understood, Your Honor. Thank you.
So Mr. Coleman, you can tell